Good afternoon. Welcome to our Lunch and Learn webinar series. Today's topic, Fundamentals of Insolvency, is brought to you today with the support of our sponsor, the University of Fredericton. My name is Wendy Morrell, and I'm the Operations and Communications Manager at the Fredericton Chamber of Commerce. Our presenter today is Robert Johnson of Allen Marshall & Associates, Inc. As a licensed insolvency trustee of Allen Marshall & Associates, Rob is active in both consumer insolvency and corporate restructuring areas of the practice. Prior to joining Allen Marshall & Associates, Inc. in April 2010, Rob was the Vice President of Ernst & Young, Inc. Corporate Restructuring Group. Rob holds a Bachelor of Business Administration from the University of New Brunswick, is a Chartered Professional Accountant, a Chartered Accountant, and a Chartered Insolvency and Restructuring Professional, and a Licensed Insolvency Trustee. In addition, Rob volunteers in his spare time as the Vice President of the Canadian Deaf-Blind Association. Ladies and gentlemen, please welcome Robert.
Good afternoon. I'd like to thank you all for attending today's webinar. As well, I'd like to thank you, Wendy, for the introduction. As well as I'd also like to thank the Fredericton Chamber of Commerce and the University of New Brunswick for allowing us this opportunity to sit down and actually discuss and hopefully provide an overview of how insolvency law works in Canada, and more in particular in New Brunswick. So to start off, unfortunately, I do have to start off with a legal disclaimer. I do apologize, but unfortunately this is necessary given that today's audience is attending via the internet, and of course the presentation will most likely be posted online for future viewing. Keep in mind that insolvency law is predominantly a federal statute, so essentially it's federal law. However, there are many provincial statutes that come into play, which the insolvency process can have small variations from province to province. So I'll strongly advise if there's anybody out there requiring any type of financial advice or services that they should reach out to a licensed insolvency trustee in their particular province, because small variations could change essentially the administration from one province to the next. So here I'll go ahead with the legal disclaimer. The information presented and discussed during this presentation is of a general nature only and is not to be taken as legal advice. Individual circumstances vary, requiring direct discussions with a licensed insolvency trustee and/or lawyer for the interpretation of bankruptcy law and related statutes based on those particular circumstances. Additionally, the topics presented and discussed are centered on both provincial and federal laws and their applicability in the province of New Brunswick at the time of this presentation today. Because just keep in mind that provincial and federal laws, not to mention common law, does change on a regular basis based on different rulings within the court system throughout Canada, and what may be applicable 1 month can change to the next month or year to year accordingly. Not to mention major amendments to legislation. So just to start off, in practicing bankruptcy, and discussions with people around in society, bankruptcy has always been regarded as a negative word that no one really talks about, as people tend to be more inclined to keep their financial issues rather close to their chest, like a deck of cards. They're more inclined to talk about their family issues, their medical issues. But unfortunately, people don't really discuss financial issues that they're faced with, nor are we taught anything about it, with regards to the education system or various other academic platforms. We just people mainly hold the belief that bankruptcy is just a bad thing to do or a bad thing to be faced with. Personally, with regards to my experience, after finishing, a 4-year business degree, I essentially had no knowledge regarding bankruptcy law or even the process. I further went on to article as a chartered accountant student for 3 years and subsequently attained my CA designation, and still, unfortunately, I had no knowledge of how bankruptcy law worked within Canada. It wasn't until I enrolled in a 4-year insolvency program where I articled and studied at the same time and eventually received my trustee license that I actually gained this knowledge and perspective with regards to bankruptcy law. I've been working within the insolvency profession since 2004, and routinely I come across many common myths about bankruptcy that people firmly believe and discuss amongst themselves. However, currently there are only 24 professionals that are actually licensed in the province of New Brunswick to actually practice insolvency or bankruptcy law. So hopefully today I can help dispel many of those myths and give everybody a general understanding of the options available and how each process works through a general overview. However, you can read about many of these myths that people commonly hold on our website at wecanhelp.ca, that is wecanhelp.ca, where we also provide a lot of facts related to those myths. Now, for today's agenda, I've kind of broken these down into several little topics, just so we can kind of build on the information as we go through. First is, what is a licensed insolvency trustee? Because a lot of people aren't aware of what a trustee in bankruptcy is. What are the root causes of insolvency? The bankruptcy process itself, which will be a general overview. Consumer proposal process was essentially a settlement agreement with the person's creditors. And a Division 1 proposal, which can be both used for the consumer and corporations. And then we'll get into directors' liabilities, guarantor issues, stakeholders' rights, and creditors' rights. Now, what is a licensed insolvency trustee? Well, the Office of Superintendent of Bankruptcy, or the Government of Canada, defines a licensed insolvency trustee as a person that's federally regulated who provides advice and services to individuals and businesses with debt problems. LITs help people make informed choices to deal with their financial issues. To further add to this description, you'll find that most licensed insolvency trustees usually have a background in accounting, so they usually hold an accounting designation or a law degree, or some sort of strong background in business and law. So they are initially professionals who actually specialize in this, this area of law or this area of finance. What does an LIT do? Essentially, the LIT, or Licensed Insolvency Trustee, represents, and the reason why I say LIT is because it's just an acronym, because Licensed Insolvency Trustee saying that over and over can take a fair bit of time. But the LIT represents a balance of interest between a person and their creditors, and is also an officer of the court. In addition to helping a person assess their situation, the LIT will give a person information and advice about both the proposal and bankruptcy processes, and plays an impartial role in ensuring a person's rights as well as the rights of those as creditors, and making sure everybody's being respected. Essentially it's almost like a LIT is a referee between a person faced with financial issues and their creditors to make sure everybody's following the law and the various rules that are in play with regards to the process. An LIT, to further add to this, an LIT will also review a person's financial situation to determine if there are any additional non-statutory options available that would solve a particular problem or financial issue and help the person avoid filing a bankruptcy or proposal. Some of these situations could involve a refinancing of assets, selling of redundant assets, identifying cash flow issues that can be corrected, among many other possible solutions. So an LIT doesn't necessarily only deal with bankruptcy or proposal issues. LIT will also seek to find out whether or not there might be other methods or solutions available that don't fall underneath the bankruptcy law. So essentially a trustee's first course of action is to see if we can help somebody avoid a bankruptcy or proposal. Now there's root causes of insolvency. There's reasons why people find themselves in financial difficulties. People don't choose to have financial issues. Essentially, they are the result of life circumstances and do not reflect on a person's character as is commonly believed, and we'll discuss this in a moment. But some of the major causes are, relationship breakdown, such as a divorce. Well, essentially, it's a situation where a person goes from a two-income household, per se, to two households, each with a single income. And this could essentially be coupled with, support payments, child support payments, etc. So the financial situation has significantly changed. So essentially, the financial obligations that were initially incurred underneath the marriage and were funded by two incomes coming in no longer works. So essentially, the math no longer works for that type of situation, which could potentially force somebody into an insolvency situation and have to look at filing a bankruptcy or proposal. Next, we have compulsive behaviors and addictions, such as substance abuse, gambling. This could be the person themselves, or it could be another family member that essentially was trying to support the person with the addiction or the medical issue, which eventually causes that person a financial issue as well. This could end up, these types of situations can end up with a dwindling of any savings or eventual credit issues due to the reliance on credit to help someone support their behavior or help somebody during their time of recovery. Essentially replacing income, whether they might be renting an apartment for them or they might be helping them with their day-to-day living costs. Then, as well, there's serious medical issues. Those are unexpected. Essentially, somebody may become unemployable as their medical issues could prevent the person from returning to work. As well, no disability insurance. Sometimes we don't have disability insurance essentially as replacement income of a lost income due to our inability to return to work due to the illness. Then we have mismanagement. A lot of this could be just based on the circumstances of life. What we commonly see is, a family funding a child's education, unexpected large expenses. Another more commonly identified issue is someone co-signing a loan for another person, and that person subsequently defaults on the payments, which then would revert that loan or responsibility of that loan back onto the person that co-signed. Then we have business downturns and failures, such as a changing economy. We are faced with recessions. We are faced with changes in consumer tastes and preferences. And then there's also regulatory issues that some businesses could be faced based on changes in provincial or federal legislation. And then more commonly, there is loss of employment or decrease in income. This could be due to your employer going insolvent or your employer closing the business, seasonal employment issues, maternity leave, where unfortunately the income does decrease during that time. And then another common thing is somebody who may have been laid off and their EI benefits have expired. essentially leaving them without a source of income. And then as well, what we've more commonly seen lately is the downturn in the oil economy out west, where people are now returning home without the higher incomes and trying to support their, their families or their household, and are unable to find suitable replacement employment here. And then as well, we also see impersonation or creditor fraud, or credit fraud. Essentially identity theft, where somebody gets a hold of somebody's personal financial information or personal information and does apply for credit, and of course runs up that credit, and there's no other way of dealing with it other than to look at a bankruptcy or a proposal scenario. And then we also see internet scams people get caught up in, unfortunately. Retirement with not enough savings, so which forces some people that are on a fixed income now to use credit to bridge their income shortfall to maintain their current standard of life. And another item would be financial literacy. Sometimes people don't understand how credit works, or they don't understand the financial agreements that they've entered into, whether it might be balloon payments at the end of the loan period. Mind you, they might be paying a small monthly payment during the course of the loan period, and totally forgotten about this balloon payment at the end, which becomes due, and they haven't planned for. As you can see, just by going through some of these root causes, many of these situations are essentially outside of a person's control and are not really a reflection of their character. Now, there is a legal definition of an insolvent person underneath Section 2 of the Bankruptcy and Insolvency Act. Insolvent person means a person who is not bankrupt and who resides, carries on business, or has property in Canada, whose liabilities to creditors provable as claims under the Act, Bankruptcy Act that is, amount to $1,000, and who is for any reason unable to meet his obligations as they generally become due. So essentially being unable to make your credit card payments, your loan payments. Who has ceased paying his current obligations in the ordinary course of business as they generally become due. Or the aggregate whose property is not at a fair market value sufficient, or if disposed of at a fairly conducted sale under legal practices or legal process, which would not be sufficient to enable payment of all the person's obligations due or accruing due. Essentially, if somebody took all their property and valued it at a fair market value, and if those items were hypothetically sold, say for $10,000, and their debt obligations are $40,000, well, unfortunately, their assets at liquidated value wouldn't be large enough to cover their obligations. Now, there is a difference between an insolvent person and a bankruptcy person, or bankrupt in general. Bankruptcy or bankrupt is a legal term. A person is not bankrupt until they file or are petitioned into a bankruptcy. Being insolvent doesn't mean bankrupt. There has to be a legal action of placing someone into bankruptcy. So it's actually a legal status. Yeah, you can be insolvent and not bankrupt. Next, what we'll do is look at essentially the bankruptcy process and how it works, essentially as a general overview. However, I will caution that a bankruptcy for one person to another person may vary based on their particular circumstances. So it's not a one-size-fits-all process, because it does change based on different factors. Essentially how this process works is usually a person will reach out to a licensed insolvency trustee who will provide a free consultation where they sit down and do an analysis of the person's financial situation, and then go through various solutions that may be available, both statutory and non-statutory, based on the person's particular circumstances. Now, the process essentially starts with, the trustees figuring out a person's assets, essentially what a person owns. And then we'll go through and figure out what the person owes, basically what their current financial obligations are. Then the person's assets are divided into 3 categories. The first being secured assets, such as a mortgage on a house, a lease or a loan on a vehicle, or another asset for that matter. Essentially, the creditor owns that asset until it's paid for. However, the debtor withhold title to it. Now, as long as a person continues paying for the asset, underneath federal legislation, they get to keep it. So if somebody had a car and they had a loan agreement against it, as long as they continue with the payments, underneath bankruptcy law, they get to continue to use that asset. So they get to continue on with the use and payment. Essentially, nobody can interfere with financial contract that's up to date when a person files and remains up to date. However, if a person falls behind on payments or stops making payments and walks away from the asset, of course, the creditor will take the asset back, so seize it, liquidate it or sell it, and apply the proceeds from the sale against the loan agreement, and then pursue the person for the differential on the loan. However, that differential or that difference deficit would get captured in the bankruptcy process. Then we have exempt assets, such as household furnishings and personal belongings in the province of New Brunswick up to $5,000. Now that's not replacement cost, that's fair market value. The way fair market value is determined is if somebody took essentially all their belongings in their house, put a big yard sale sign in front, and were to sell it. So you probably, replacement cost might be 30 or 40,000 for everything there, but selling at a yard sale value or Kijiji value, they might be only getting 10 to 20%. So it's not what the replacement cost is what the actual value of it is in today's market, sold as is, where is. A person's allowed to have a vehicle that they own outright worth up to $6,500. And as well, if somebody's a tradesman or a sole proprietor, they can have tools of the trade. So essentially, assets that are used to generate income worth up to $6,500. Then we have another category of assets that essentially doesn't fit into those 2 categories, and those are called non-exempt. And that would be like equity in a house. So hypothetically saying, if a person sold their house in today's market as is, where is, what would they anticipate a person to write on a check for it? Well, we look at that, and then we look at what the outstanding mortgage might be on the house. We factor in, selling costs, because you're going to have to pay a realtor to sell it. You're going to have taxes on the sale of the house, and then you're also going to have legal fees. Then whatever's left over, what is essentially what we consider equity. RESPs, so Registered Education Savings Plans. We look at the cash surrender value of those. Balance in an RESP might be $4,000, but that's not really the cash surrender value because you have government contributions, government growth, and some interest in there. So cash surrender value, if the plan were collapsed, the government takes back its contributions to the plan and leaves essentially what the debtor contributed to the plan. So hypothetically, if the plan's at $4,000, well, there could be only $3,000 in contributions, and that would be considered a non-exempt asset. RRSPs. RRSPs are another unusual item where RRSPs and contributions in the 12 months prior to bankruptcy are considered non-exempt. Contributions older than 12 months are exempt. So anything older than 12 months is considered an exempt item and therefore not available for a person's creditors. And not to mention there's many other different things that may fall into this non-exempt category. Well, underneath bankruptcy law, essentially the trustee is required to turn these non-exempt assets into cash, essentially to pay back the unsecured creditors a percentage on the dollar what they're owed. Now the trustee has two different ways of doing this. The first way is we usually value these non-exempt assets and give the debtor the ability to essentially pay the trustee for them, and then the trustee takes that cash and gives it to the creditors on a percentage basis. However, underneath federal legislation, the trustee does have the ability to seize and sell assets and essentially sell them and to give the money to the creditors. However, we normally prefer the first option because creditors want cash, they don't want assets. So as long as the creditors are getting the cash for these assets that represents the fair market value, they're happy. Now the way this process gets initiated is essentially a person would execute the documents to file a bankruptcy, so put them into a bankruptcy status. And what that does is it puts up a wall or a legal stay of proceedings between the person and their creditors, where the creditors can no longer pursue the debtor with regards to collection, interest, fees. Legal actions are, with regards to civil matters, are stayed. Calls from creditors cease as well. So essentially the trustee becomes like a referee between the creditors and the bankrupt. So essentially the creditors have to deal with the bankrupt from that point forward and are no longer allowed to actually contact the bankrupt. Now, while somebody's in bankruptcy, they have to do various things. Like every month, they have to report their monthly income and expenses. So the trustee will usually prepare or provide them with forms where they have to fill out what their debt earnings are for the household and where they spent it every month. A person has to attend 2 counseling sessions. Those are usually half hour each, and they're usually held in the trustee's office. The first one is, and it's all based on mandated material. The first one usually contains information with regards to budgeting. And the second one is more focused on financial planning and estate planning, etc. Now, the creditors do have a right to call a creditors meeting underneath the personal bankruptcy. However, it's not that common. It's rather rare, unless there's some sort of financial issues or complicated legal matters that need to be dealt with, or if a person's unsecured or non-exempt assets are equal to or greater than $15,000, then a meeting is required underneath the legislation for the creditors. And as well, if a person's non-exempt assets are greater than $15,000, there's also public notice required with regards to the person filing bankruptcy. A person always has is required to assist the trustee throughout the whole administration, whether providing information, dealing with assets, etc. And a person has to pay a monthly fee or surplus income. Now, surplus income, what that's all about is the superintendent of bankruptcy has set guidelines, what it considers minimum income thresholds after tax that a person or a household has to earn to maintain a minimum standard of living. For a single person, it's a net income of $2,121. For a family of 2, it's $2,640. However, this whole scheduled based on the number of people in the household. So anything above this threshold, and we're talking net income, is considered surplus. From that surplus, the trustee will look at other expenses that we consider non-discretionary, things like spousal support, child support, medical bills, expenses where legal stay of proceedings has been lifted by the court. And we subtract that off that surplus. And if there's anything left over, we then take that amount and we divide it by 2. Essentially, the debtor keeps half, and the other half comes to the estate for the benefit of creditors. Now, if there is a half, after all that calculation comes to the estate, and it's $100 or more a month on average, that's essentially the court will extend a person's bankruptcy by an additional 12 months. Now, for a first-time person going through bankruptcy, it's normally a 9-month period. However, like I was just saying, underneath that surplus income calculation, a person could be extended for an additional 12 months for a total of 21 months. However, if a person is below that guideline, they're most likely subject to a basic administration fee, and those can vary from trustee to trustee, but they're usually based on some sort of monthly payment plan during the 9 months. Now, there's also a dispute resolution within the bankruptcy process. So essentially, if a creditor has an issue, or the superintendent of bankruptcy has an issue, or the trustee has an issue with the bankrupt's conduct throughout the whole process, they can oppose a person's discharge, essentially keep a person in bankruptcy longer. However, if anything like that does happen, underneath the legislation, a person has the right to mediation. Essentially, it's where everybody sits down through a formal mediation process, and they discuss the issues, and they negotiate some sort of resolution or compromise. However, if that does fail, then all other matters have to go before the court. Now, keep in mind, this whole process is actually a court process, and like I previously mentioned, trustee is an officer of the court. And when the court's looking at a situation, so it's a formal court hearing, the court has got 4 different ways of dealing with things. The court, can look at the situation and say, the bankrupt didn't do anything wrong, they did everything right. So the court would essentially issue a person their absolute order of discharge, so release them from the bankruptcy. The court can also issue a conditional order of discharge. That usually pertains to essentially the bankrupt not completing all the requirements of the bankruptcy. So the court will issue a conditional order of discharge, essentially saying until all the requirements of your bankruptcy are completed, you'll stay in bankruptcy until they're done. Court can suspend a discharge. That would be normally when somebody has committed some sort of act or violation of bankruptcy legislation. Whether they hid assets, they hid income, or there were some other conduct issues that the court considered egregious. And the court can also refuse a discharge. And that's a rare thing. In fact, in my practice, I've never seen it. However, the court can refuse a discharge, and based on my understanding, that's usually in situations where somebody's been abused in the process. Somebody's gone bankrupt 4 or 5 times. The court just determines that the person shouldn't be released from the bankruptcy status, and essentially keeps them in bankruptcy forever. Now, there are certain debts that don't go away in bankruptcy. I'll go through the list here in a second, but essentially they're all essentially nasty things. And you would expect these types of things to actually survive a bankruptcy. Essentially, debts arising out of sexual assault, harassment, bodily harm, debts arising of misrepresentation, fraud, embezzlement, court-imposed fines and penalties, child support, alimony, and student loans where a person has been out of school for 7 years. So those types of things, as expected, would not be discharged through the bankruptcy process. Now, with regards to student loans, if a person has been out of school for 5 years and not 7 years, they can make a special application underneath legislation to have a court hearing to try to get their student loans included. However, that would be more of a discussion on a one-to-one basis that a person would have to have with their trustee. However, if somebody has not been out of school for 7 years, their student loans would survive a bankruptcy. Now, bankruptcy also puts an R9 on a person's credit rating for 6 years after they're done. It doesn't mean no credit, just means they're going to be paying higher interest rates, and some lenders will not deal with them and other lenders will, based on their credit policies. But that starts after a person gets out of bankruptcy. And like I said, for a first-time bankruptcy, it could be 9 or 21 months long based on your household income. Now, credit ratings, they go from, just to give some overview, go from an R0 to an R9. And they're rated 0, 1, 2, 3 through 9. R9 is usually on a person's credit report, bankruptcy or non-collection of debt. R8 would be repossession of an asset, so the bank taking foreclosure in a house or a lender taking back a vehicle. R7 would be for a proposal or settlement arrangement. R6, depending on the agency, it could be blank or it could be a collections debt. R1 is person has everything current, and R0 is essentially an 18-year-old with no credit. And then you have everything between 1 and 6 based on 30 days, 60 days, etc. Now, in addition to the non-exempt assets coming to the estate to pay the creditors and the surplus income or the monthly fee, administration fee, GST checks, if a person were to qualify for GST while they're in bankruptcy, those would come to the estate, and income tax refunds for the year of a person's bankruptcy, and if there were any prior outstanding refunds, would come to the estate for the benefit of creditors as well. So again, this is just a general overview, and everybody's situation can vary based on their own particular set of circumstances. Next, we have under this legislation what they call a consumer proposal. It's essentially where a person is trying to make a deal with their creditors to pay them back so much on the dollar. This is done by making monthly payments to the trustee, usually over a 5-year period. The maximum allowed underneath the statute is 5 years. Now, after a person's finished their proposal, usually 5 years long, and R7 goes on their credit rating for 3 years after completion. Just like I mentioned, the scale of how credit ratings work, R7 is above a bankruptcy. However, still within that risk category when a creditor is looking at credit worthiness with regards to a person. Now, creditors also get to vote on a proposal. And creditors get 1 vote for every dollar they're owed. And we're talking unsecured creditors because if a person's keeping their house or their vehicle, those would be secured creditors because they have a lien on the asset. And if the person's going to continue making payments on them, well, that gets excluded. However, Visa, MasterCard, bank loans, etc., are included. And like I was saying, creditors get 1 vote for every dollar they're owed. So if, say, RBC Visa is owed $10,000, well, they get 10,000 votes. Say they have an MB Power account for $1,000, well, MB Power gets 1,000 votes. So essentially, creditors vote with what they're owed, and you need 51% to vote in favor to get the proposal accepted. Now, if a creditor were to vote against the proposal, but yet the majority of the creditors voted in favor of the proposal and the 51% threshold is achieved, the person or the creditor that voted against the proposal is automatically included underneath the legislation. They can't try to carve themselves out. It's an all or nothing situation. So essentially, when creditors are looking at voting for or against a proposal, they first look at what's this person really worth to us underneath the bankruptcy scenario, because the thought process is essentially, we don't accept this proposal, the chances are the person's probably going to be filing a bankruptcy. Well, what's the person offering underneath the proposal? Is the proposal going to give the creditors less than, equal to, or more? Well, the name of the game, unfortunately, comes down to cash, and it has to be to the benefit of the creditors. Why would somebody vote for something that gives them less than or equal to the alternative of bankruptcy? So proposals tend to cost people more. Now, there's also a debt cap on filing a proposal. Essentially, the debts captured underneath the consumer proposal have to be less than $250,000 in aggregate, excluding the mortgage on a person's principal residence. So somebody owed $260,000 in loans and credit cards, well, they would no longer qualify for relief underneath the consumer proposal. And as well, underneath the proposal, a person has, if the proposal is accepted, they still have to attend the 2 counseling sessions, which is essentially the same mandated material that's included underneath a bankruptcy. And the way this process works, essentially, a person sits down with their trustee and they figure out, okay, what's this person worth to their creditors underneath the bankruptcy? It's kind of the starting point. Well, what would be a viable offer to their creditors? So they formulate the offer, and then they sign all the legal documents, and then legal stay of proceedings goes into place, just like bankruptcy, where it prevents the creditors from pursuing the person any further. The trustee then sends the proposal to the creditors, and the creditors have 45 days where they can vote yes, no, they can remain silent, and they can also request a meeting. So if the creditors vote yes, Then there's another 15-day period where the creditors or the superintendent's office can request the court to review the proposal. In my practice, I've never seen this type of application occur. It's usually just the proposal that it's almost like a safety net within the system. So if there was something that a trustee was unaware of, or if a creditor had an issue, they can appeal the process to the court for review and possible annulment of the proposal or some other remedy that may seem fit. But usually the time period comes and goes, so it expires, and the proposal is deemed to be ratified in its legislation. Then essentially a person moves forward and completes their proposal and is issued a certificate of full performance. Now, alternatively, if the creditors were to refuse the proposal, so if the person doesn't achieve the 51% vote required, there's no automatic bankruptcy. It kind of just leaves the person where they are. So then they have to seek some sort of resolution, whether they try to backtrack and continue to deal with their creditors on an informal basis. The person can file bankruptcy. That's always available. Or a person can file a Division I proposal. Now, Division I proposals it's a different type of proposal from a consumer proposal, as a Division I proposal can be used for both consumers and businesses. However, if a corporation were to try to seek relief with regards to its debts underneath a Division I proposal, the corporation would still have to show that it can still be viable on a continuing basis. But to start off in looking at the consumer situation underneath the Division I proposal process, it's just like a consumer proposal where they're trying to make a deal with their creditors to pay back a certain amount of their debt by making monthly payments to the trustee. It still has the same credit rating of an R7 on their credit rating for 3 years after completion. The creditors vote on the proposal and they still get the one vote for every dollar the road. However, the voting threshold changes significantly. That it's not 51% like a consumer proposal to have it accepted. It's 66 2/3% of the dollar value voting, plus majority in number of creditors. So if somebody has 5 creditors, they need 3 to vote in favor. So it's a double threshold that has to be achieved to get this type of proposal passed. And again, the proposal would have to offer creditors more than they're going to get in a bankruptcy scenario. And the way this process usually starts is just like the consumer proposal. The person would sit down with their trustee and do the analysis of what they're worth to their creditors in a bankruptcy, and then formulate some sort of repayment scheme or settlement with their creditors. And the trustee would then file the proposal. Stay proceedings would go into place, where the trustee sends the proposal to the creditors, and they only have 21 days versus the 45 underneath the consumer proposal to prove how much the debtor owed to them and then vote. And then on day 21, there is a creditors meeting where essentially the creditors essentially are invited to usually a trustee's office or some other location to review the votes and determine if the proposal passes or fails. Now, if the proposal does pass, so it meets the threshold of 66 2/3% plus majority number of creditors, the trustee would then proceed with making an application to the court for ratification of the proposal. But usually, if the creditors are voting for the proposal and the proposal has been accepted, the court would rarely interfere with that because it is the creditor's wishes to accept the settlement. However, if there was some sort of technical default or technical issue with the proposal, the court could amend the proposal or annul it at that point in time or refuse to pass it. However, it's court ratification, so if the court does accept the proposal or ratifies it, the person would essentially move forward and complete their proposal by their monthly payments or whatever settlement might be formulated, and then a certificate of full performance would be issued. Now, however, if the creditors vote against the proposal or if the court refuses to pass or ratify the proposal, would actually put the person into an automatic bankruptcy. So there's no choice. There's no backtracking with the ability to deal with persons creditors on an informal basis or any other avenues available. It's just an automatic bankruptcy. However, for a consumer, there's no public notice required in the paper. Essentially, it's a quiet interest into a bankruptcy situation, and it's normally used for most professionals that have public relations or certain professional requirements that actually prevent them from publicly disclosing that they're in a bankruptcy. Now, with regards to a corporation, there are several different variations that I've seen with regards to settlement with creditors. I've seen repayment schemes over a time period as well. Underneath Division 1 proposal, unlike the consumer proposal, there's no mandated maximum period underneath the Division 1 proposal like a consumer proposal. Consumer proposal is a maximum of 5 years. However, a Division 1 proposal can exceed that. I've seen corporations enter into settlement agreements where they're repaying monthly payments or annual payments to their creditors, some sort of repayment scheme. I've seen corporations issue shares in lieu of debt. I've seen corporations issue debentures or various other different types of securities. Now, with regards to a corporation filing a proposal, usually the first step is the corporation would file a notice of intention to file a proposal, which automatically puts up the legal state of proceedings between the corporation and its creditors. So the creditors can no longer pursue the corporation. It gives the corporation time to essentially sit down and formulate some sort of an offer to their creditors. However, within 10 days of filing a notice of intention to file a proposal, the corporation needs to file a cash flow statement with the superintendent's office, essentially showing how the cash flow or the business is going to operate on a go-forward basis. Now, this notice of intention period, the initial stay period, is usually 30 days. Then the corporation has the option of either filing a proposal or applying to the court for additional extension of time. And those can be additional 45 days increments up to an additional 5 months in total. So essentially, a proposal or a notice of intention period where the corporation is restructuring can be up to upwards of 6 months long for the initial stay period. And of course, with regards to filing the proposal, the creditors have the 21 days to review the proposal and vote. Then there's usually the creditors meeting where all the creditors get together with the trustee and the corporation executives or persons of interest and review the voting period and determine if it passes or fails. And again, if the proposal isn't accepted by the creditors, it's automatically deemed to put the corporation into bankruptcy. However, again, the creditors accept the proposal, then there's the 14-day period where the trustee makes an application to the court to have the court review the proposal to determine if it falls within the guidelines required. And if the court says yes, of course, the court's ratifying, and then the corporation will move forward and complete the proposal. Again, if the court refuses to ratify the proposal, the corporation would obviously be placed into a bankruptcy. Now, the other side to consider with a corporation filing a proposal or Division 1 proposal, and there's some sort of settlement of debt, well, underneath the Income Tax Act, it's considered a forgiveness of debt, which then could potentially have income tax applications for the corporation for that forgiveness of debt, because there is a bit of a formula there that would have to be taken into consideration whether there is going to be some sort of tax consequences to the settlement with the creditors. And the other important facts with regards to a corporation filing a proposal that is accepted, that any payroll remittances that are outstanding with the CRA would have to be paid within 6 months after acceptance of the proposal. Payment of any type of preferred claims, there's different types of claims underneath the Act, and preferred claims fall under Section 136. And those have to be paid in priority to all the other creditors. And if the company were to owe payroll to its employees, that has to be paid immediately upon acceptance of the proposal as well. So there is some other criteria that have to be taken into consideration as to whether the corporation can not only complete the proposal, but also handle these additional factors that need to be taken into consideration. So if a corporation were to have high amounts of outstanding payroll remittances, well, that could potentially impair the corporation from filing or completing a successful proposal. Now, the other issue that usually pops up from time to time is directors' liabilities or guarantors' liabilities. Somebody that's essentially guaranteed the debt of another person or a corporation. Now, with regards to directors' liability, so directors of a corporation, they are personally liable for certain expenses of the corporation on a personal level, such as HST that's been unremitted. A corporate director is personally liable. Outstanding payroll deductions that weren't remitted to the CRA. Personal guarantees on debt. So if a corporation were to borrow money from the bank and a director or a person within the corporation essentially co-signed or guaranteed that debt, well, if the corporation were to become insolvent, unfortunately, that debt would then fall onto the person that co-signed or guaranteed the loan. So in the personal capacity, they then become responsible, usually on a joint and severally liable situation where they are now essentially faced with paying the debt that the corporation didn't pay. Certain environmental issues director can be personally liable for as well. And unpaid wages and employee and vacation pay. In the province of New Brunswick, I'm not aware of any changes lately to the New Brunswick Business Corporations Act. So if the corporation is provincially incorporated, that's usually not an issue. However, if the corporation is federally incorporated, so underneath the federal statute, a director can be held personally liable for those unpaid wages and vacation pay. Now, just to backtrack a little bit here, with regards to an insolvent corporation, it's quite rare that we actually put a corporation into bankruptcy. Most of the time, it's usually because the corporation or the business is no longer viable. So we usually then focus on the directors or the owners of the business and look at what the personal issues might be, or personal financial issues might be with regards to the corporation shutting down. So essentially all the HST, the payroll remittances, personal guarantees, what the owner becomes personally liable for. So usually in most circumstances, we end up closing the business and then focusing our attention on the primary stakeholder of the corporation and to see what kind of collateral damage is coming at them with regards to the finances of the corporation. And then we usually consider a proposal or personal bankruptcy for that person. And just like I was saying, you know, corporate bankruptcies, I wouldn't say are rare, they're just not as common as a personal bankruptcy. Because corporate bankruptcies can tend to be very expensive and usually only make sense if there are significant assets in the corporation that the trustee can liquidate and essentially use for distributions to the creditors, so some sort of repayment on what their liabilities or what they're owed. Stakeholder issues. So somebody owns a company and the company becomes insolvent. Well, there's several things that there are several items of concern that should be reviewed. You know, because anybody that's invested money in the company is essentially going to lose that investment because creditors always come before investment or shareholders. So they always get paid in priority, and usually, more often than not, any investment in a company is unrecoverable. Loss of funds loaned to the company. Most of the time when people set up their businesses, they usually start off with some sort of personal loan to the company with their cash to, you know, handle the day-to-day or setup of the company. And unfortunately, that most likely is not going to be repaid to them or is non-recoverable. And then again, we have the director's liability and personal guarantee issues that usually fall back to the principal owner of the company or the directors of the company, and those have to be reviewed as well. And not to mention CRA, the Canada Revenue Agency, from time to time may hold what they call a deemed trust on the assets of a corporation for things like HST, source remittances, or payroll deductions, meaning that CRA actually holds a priority claim or priority position on the assets of a corporation. So they actually get paid first before any of the other creditors would get paid. And this is underneath both the Income Tax Act and the Bankruptcy Act. So they do hold a priority position for those. Now, here's another question. What would happen if you're in business and one of your customers becomes insolvent, or one of your customers goes bankrupt? Well, unfortunately, you could be unsecured for any of your outstanding receivables, meaning that you don't really have any recourse for recovery, other than maybe going to the court and obtaining what they call a court-ordered judgment, essentially certifying that the person owes you the money, and then you can look at your remedies with regards to enforcing that. If you were to hold security on the person's assets, or corporation to corporation, essentially essentially the agreement or the credit agreement would form some sort of lien on the person's assets for non-payment of their obligations to your corporation. This is more commonly done with banks or financial institutions when they lend money to a corporation or an individual. They usually take something, a security back, with more commonly termed general security agreement, which essentially uses all the person's assets or the corporation's assets as collateral against the loan that's been issued. In the event that the loan's not repaid, they have those assets to liquidate to try to recover some of the principal portion of the debt that's outstanding. Another avenue a person or company might have with regards to their customer going insolvent or bankrupt is that there could be a potential recovery of the products sold under two different sections of the Act. Section 81.1 provides that if you were to deliver products or some sort of goods to a corporation, within 30 days of them filing bankruptcy, there could be the avenues underneath the legislation to recover those goods. However, there are certain conditions with regards to that, and you would need to obviously speak with a lawyer or a licensed insolvency trustee to find out what the requirements are. For fishermen and farmers and aquaculturists, there's also a 15-day window. So if you were to deliver those type of products or be in those types of occupations and deliver goods to someone that eventually goes bankrupt within 15 days, there's also a provision underneath the legislation where you may be able to retain, reacquire those goods or have some sort of payment for those goods. Now, again, if your customer were to go bankrupt, you'll obviously be dealing with a licensed insolvency trustee. And the licensed insolvency trustee will most likely send you out notice of the bankruptcy, as well as a proof of claim form, which is essentially a form that, as a creditor, you would fill out that form identifying who you are, how much you're owed, provide proof of how much you're owed, and as well, usually, if there's going to be a creditors meeting or some sort of issue that needs to be voted on, there's usually a voting letter attached as well, where you can vote yes or no, or you can show up at the creditors meeting and vote with your claim. But again, if that type of scenario happens, I strongly encourage you to reach out to a lawyer or a licensed insolvency trustee to get into more details about that whole process and what your rights are. Now, in New Brunswick, creditors do have rights, just like debtors have rights. In the province of New Brunswick, only the Canada Revenue Agency and Family Court can garnish the person's wages. Regular creditors cannot do that underneath, there's certain provisions underneath a couple different provincial statutes. Please don't investigate civil matters. So, please don't show up at your door for owing Visa $10,000. There's no debtor's jail in Canada, so you can't go to jail for owing money. However, secured creditors can seize their assets for non-payment. And a creditor can litigate in civil court and obtain a court judgment. And I was previously speaking to this. And that's essentially where a creditor goes to court and essentially has the court certify that a person owes them the money. And it's all within a legal document with the judge's seal and signature on it. And the creditor can then take this judgment and do one of two things. The creditor can try through the sheriff's office, seize non-exempt assets and liquidate them for their benefit, or the creditor can take this judgment and register it in land titles against real property that the debtor might own, and then essentially wait for the person owning the property to either refinance or do something with regards to the title, and the creditor then, or sell the land, of course, and then the creditor would essentially obtain the face value of their judgment, plus if there is provision for interest, and essentially get paid that way. Now that kind of concludes, like I said, this is just a quick general overview of how the insolvency process works. I hope I've enlightened you a bit and given you some awareness of the various insolvency solutions available. However, we at Allen Marsh & Associates are always available free of charge, and obviously on a confidential basis to discuss any matters dealing with a person's financial difficulties or a business financial difficulties, and essentially go through any options may be available, whether they be statutory or non-statutory options. Again, I'd like to thank Wendy and the Fredericton Chamber of Commerce and the University of New Brunswick for allowing us to have this opportunity to sit down and speak with you today. Thank you.
Well, that was great. Thank you for all the information. Robert, as an appreciation for your time and expertise, the Chamber will be making a donation in your name to the Scholarship Fund. I would once again like to thank and acknowledge the University of Fredericton for sponsoring our Lunch and Learn webinar series. If you'd like to watch this webinar again, or if you'd like to pass it along to your coworkers, it will be posted on the Chamber's website and our YouTube channel within the next week or so. So thank you, everybody, and have a great day.